Hello, and welcome, and get ready to start casting a lot of silent votes in all our cases we explore today to see if you came down where the courts came down. My name is Peter Afrasiabi. I am an intellectual property litigator at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. My practice focuses on copyright, right of publicity, trademark, and related privacy torts. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my students, as well as an advocacy and persuasion course. I have taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone, and are not the views of my law firm, the university, or any other academic institution or entity I work with. Today's program is where art meets commerce. We ask, is an object art or a commercial product not subject to art-based legal protections? Along the way, we will look at a variety of products to explore this fault line in the law, from expensive handbags, dog toys evocative of Jack Daniel's whiskey bottles, cat lamps, museum-hanging Chinese art bag lanterns, to a Spanish galleon bus used at the Burning Man Festival in the desert, and more. And again, for fun at each step of the way, I will show the object, let you decide what you think, art or commerce, and then we will proceed to the analysis to see if your art versus commerce intuitions are right or wrong. This will take us through copyright law, some trademark law, and artistic integrity laws. And we will start with a seminal old Supreme Court case that pit Justice Holmes against Justice Harlan, a case that really defines our modern art versus commercial product world, even over a century later. But first, and briefly, I want to tell you more about the Curious Lawyer series that we have created for you, a true curious lawyer. The Curious Lawyer series is a fun, educational, and entertaining walk down some of the off-the-beaten paths of law, areas that you do not experience in your regular practice day to day, but which are incredibly interesting and informative, and often yield new insights and valuable analogies or metaphors that you can work with in your practice. In this series, we take a variety of interesting issues and intersect them with the law to find fascinating, new, educational, and informative areas of the law to explore, and to better educate you about legal areas you may not know. For example, we have done programs on dog law where you get to think about your favorite furry friend and see how our relationship with dogs intersects the law, from tort to contract law, to even trusts and estate battles over dogs. And, of course, Fourth Amendment cases where there have been warrantless removals of dogs from homes for violating the leash laws. Or you can see the CIA law program, where you will see fascinating legal topics related to the CIA, secrecy, and the Freedom of Information Act, and where you will learn about that famous Hollywood movie line, I can neither confirm nor deny. You will learn where it came from, and it turns out it was not Hollywood, but you have to watch it to learn who came up with it. We have also looked at whether there's a little sliver of Yellowstone National Park, where, due to a combination of the Sixth Amendment's vicinage requirements and the subsequent federal districts that were created by Congress to sit over the nation, whether that, in fact, has actually yielded a sliver of land in our famed Yellowstone that is free from federal criminal prosecution. Is it a perfect crime zone? Listen to that program and you will find out. And if you want to brush up on the Bill of Rights, we have a 10-part series with 1 hour devoted to each of the first 10 amendments to the Constitution, so that you, at the next cocktail party, can answer when a non-lawyer asks you what one of the amendments is all about. The one thing the Curious Lawyer series is not is boring. This is most definitely not your typical continuing education that is often technical, difficult, or stressful. So sit back and grab a cocktail, if you are so inclined, and let's get going in our fascinating, curious exploration of the line between art and commerce. Today's program is looking at the fascinating question of whether certain artistic creations are art or copyrighted creations within the law, or whether they are really just commercial products, not subject to the same copyright protections for other artistic products. This takes us into the fascinating inner workings of copyright law, trademark laws designed to protect artistic integrity, such as the Visual Artists' Rights Act, and a look at fun and interesting judicial opinions assessing whether particular items fall within the realm of the law's protection or constitute really commercial products. So you will get an IP overview of copyright and trademark as we analyze these art versus commercial product cases. We will look at some foundational battles between Justice Holmes and Harlan over this very set of questions, and their battle in the earliest days of the 20th century carry forward to the present day. This will give us a chance to look at very expensive and famous Hermes bags, art used at festivals, lanterns hanging in the courtyards outside of museums, sculptures, circus advertising, the Burning Man bus, and many more fun and interesting creations. And yes, you heard that right. We are going to Burning Man in this program. Let's start on this slide. We're taking a look at this picture on the left. You can see it as a creation of some kind. Is it a commercial product that is a manufactured piece of metal, or is it art? Is it an artist's vision of a bird, or a piece of metal subject to import duties? Place your bets and make your decision as you look at this, because we are going to look at the case that raised this question, which goes back to the early 20th century, which really is the beginning of our odyssey through the law's intersection with commercial products and categorizing them as either commercial products or artistic creations and designs. The case is Brancusi versus United States Customs Department, reported at 54 Treasury Decision 429 from 1928. Here are the basic facts that started this question we address today as we move from 1928 to the modern day. This thing, and I call it a thing for now, so as not to prejudge it as art or a commercial product, showed up on our shores as it was being imported. The customs collector stopped that product and put a tax on it, based on the law related to taxes on manufacturing of metal products, things such as cutlery. The owner was not happy and challenged it. Here is how the judge described it. The piece is characterized, as stated above, as a bird. Without the exercise of rather a vivid imagination, it bears no resemblance to a bird, except, perchance, with such imagination it may be likened to the shape of the body of a bird. It has neither head nor feet nor feathers portrayed in the piece. As stated above, it is entirely smooth on its exterior, which is a polished and burnished surface. Both the government and the artist brought forward experts to challenge whether the work was one of art or a commercial product, subject to the importation taxes. The government experts said it was neither art nor a sculpture. The artist experts, of course, said the opposite. The court 100% recognized that the product was created by an actual professional artist with a significant reputation in the creation of artistic works. And the court held. Since 1916, there has been developing a so-called new school of art, whose exponents attempt to portray abstract ideas rather than to imitate natural objects. Whether or not we are in sympathy with these newer ideas and the schools which represent them, we think the fact of their existence and their influence upon the art world as recognized by the courts must be considered. The object now under consideration is shown to be for purely ornamental purposes, its use being the same as that of any piece of sculpture of the old masters. It is beautiful and symmetrical in outline, and while some difficulty might be encountered in associating it with a bird, it is nevertheless pleasing to look at and highly ornamental. And as we hold under the evidence that it is the original production of a professional sculptor, and is in fact a piece of sculpture and a work of art. According to the authorities above referred to, we sustain the protest and find that it is entitled to free entry. Thus, the customs inspector's decision that it had to be taxed as a commercial product was wrong. So those of you who voted art, you were right. And this gets at a critical line in the law for courts, and that is the courts must tread very carefully in deciding an object is not art. Let's now see where that line developed just a few years before our bird or commercial item case. Take a look at this. It is a poster from the early 20th century for a circus. Is it protected art? That is it copyrighted art? Or is it advertising material and too commercial and thus not subject to protection? Take a moment and cast your silent vote to yourself. Here is a basic, long-standing statement of copyright law from the United States Supreme Court on the riddle. Indeed, danger of courts wading too deep into these questions. You probably now have a sense of if you voted correctly. It is from Bleistein versus Donaldson Lithographing in 1903, and the words are from Justice Holmes. The lithograph on the screen here was an advertisement for a circus that the plaintiff created and sold to the circus company. The circus ran out of posters and did not reorder form the plaintiff. It reordered copies form the defendant instead. The plaintiff then claimed that when it was made by the defendant, it was an infringement of its work. The defendant denied it was copyright worthy. Justice Holmes said, quote, "It would be a dangerous undertaking for persons trained only to the law to constitute themselves final judges of the worth of pictorial illustrations, outside of the narrowest and most obvious limits. At the one extreme, some works of genius would be sure to miss appreciation. Their very novelty would make them repulsive until the public had learned the new language in which their author spoke. It may be more than doubted, for instance, whether the etchings of Goya or the paintings of Manet would have been sure of protection when seen for the first time. At the other end, copyright would be denied to pictures which appealed to a public less educated than the judge." End quote. That case, of course, involves a photo. So is an easier call than our customs detective confronted looking at an object that may be a sculpture or maybe some sort of product. But that key point is the through line within the law. However, 2 justices dissented and said this was not fine art within copyright law. Let's look at what they said. So here is what the dissenters said. Quote, "What we hold is this, that if a chromo, lithograph, or other print, engraving, or picture has no other use than that of a mere advertisement, and no value aside from this function, it would not be promotive of the useful arts within the meaning of the constitutional provision to protect the author in the exclusive use thereof. And the copyright statute should not be construed as including such a publication if any other construction is admissible. If a mere label simply designating or describing an article to which it is attached, and which has no value separated from the article, does not come within the constitutional clause upon the subject of copyright, it must follow that a pictorial illustration designed and useful only as an advertisement, and having no intrinsic value other than its function as an advertisement, must be equally without the obvious meaning of the Constitution." They went further. Quote, "We are unable to discover anything useful or meritorious in the design copyrighted by the plaintiffs in error, other than as an advertisement of acts to be done or exhibited to the public in Wallace's show. No evidence, aside from the deductions which are to be drawn from the prints themselves, was offered to show that these designs had any original artistic qualities. The jury could not reasonably have found merit or value, aside from the purely business object of advertising a show, and the instruction to find for the defendant was not error." End quote. That is a huge fault line, and it shows the dissenters saw a role for the court to make artistic judgments about the worth of a creation, and to delimit the Constitution's grant of copyright away at least most narrowly from advertising materials. Holmes versus Harlan, and Holmes won, and this casts a very long shadow all the way to today. Thus, the majority prevailed, and this means to this day courts stay out of it as much as possible and concede wide deference to our artistic creators. This brings us to some basics on copyright law as it grapples with copyrighted creations on the one hand versus non-copyrightable utilitarian products. Here is a quick overview of copyright as it relates to this issue, and some copyright-based fault lines that flow from the U.S. Code and the Supreme Court holding we just saw. These are issues we will start exploring. What you see on our slide here in short form is a statement of the law between art and useful utilitarian objects. This comes from the Ninth Circuit Jury Instructions on Copyright Law and is a basis statement of national law. Here is the full statement. A useful article is something that has an intrinsic use beyond displaying the appearance of the item or conveying information. A useful article, in and of itself, does not enjoy copyright protection. However, the pictorial, graphic, or sculptural features of the design of a useful article are copyrightable if they can be identified separately from and are capable of existing independently of the utilitarian aspects of the article. The utilitarian aspects of the article are those aspects that make it useful. For example, a generic lamp base consisting of a post and wires is not copyrightable because it is a useful article with no separable copyrightable features. But if the lamp base is in the shape of a cat, the cat design itself might be copyrightable because the cat design of the base can be viewed separately from the lamp and is capable of existing independently of the lamp. That was the jury instruction from the Ninth Circuit, and so you can see an example here in the photo that depicts this line in the law. Let's go from broad statements of the law and cat lamps to three-dimensional costumes like this on this slide. This is from a real case, which we will look at in a moment. The question for all of you is whether this is copyrighted protectable art or if it's a functional commercial product not subject to copyright protection. Again, take a moment and get ready to see if your vote is how the courts came out. The case is Entertainment Research Group versus Genesis Creative Group, reported at 122 F. 3rd 1211 from the Ninth Circuit in 1997. Here are our basis facts in the dispute. Plaintiff ERG designs and manufactures three-dimensional inflatable costumes that are used in publicity events, such as shopping mall openings. The costumes are approximately 8 feet tall and are worn by a person who remains inside the costume. Various companies purchase and use these costumes to promote their products. The costumes are based upon these companies' cartoon characters rendered in 2D that were copyrighted. As always, the business relationship between ERG and the defendant broke down, and the defendant sourced the costumes elsewhere. ERG alleged that Aerostar copied and infringed ERG's copyrights when it made the inflatable costumes that ERG designed and manufactured based on its underlying copyrighted characters. The district court found no copyright in the 3D costumes based on the 2D characters. That is, the copyright in the 2D's character. The Ninth Circuit ruled that functional elements get no copyright protection. Even lots of effort to convert 2D to 3D does not amount to an original new creation of non-functional elements. It was undisputed that ERG's costumes are based upon two-dimensional characters that are copyrighted and owned by the purchasers of the costumes. The question then was whether the conversion from 2D to 3D so they could be worn was an unlawful derivative work based upon the 2D's character. The Ninth Circuit then looked at the 3D's elements to see if they were a functional product or protectable art. Specifically, aspects of ERG's costumes that are purely functional, utilitarian, or mechanical will not be given any copyright protection. The question then was whether any artistic differences in the costumes are merely trivial and driven by functional concerns. And viewing the three-dimensional costumes and the two-dimensional drawings upon which they are based, the court ruled that it is immediately apparent that the costumes are not exact replicas of the two-dimensional drawings. And any differences that exist because of functional or mechanical considerations, such as the need to make it fit a human, do not count as artistic creation. The Ninth Circuit then held as follows. Quote, "We agree with the district court's conclusion that the differences in form, texture, and proportionality that ERG points to as non-trivial differences all stemmed from functional considerations. Thus, costumes not copyrightable." End quote. This now brings us to another copyright art versus useful article in commerce and not art type case. This is the cheerleader uniform case. Let's see how the cheerleader uniform compares to the character costume. So before we get into the case, take a look at this picture here and decide if the cheerleader uniform design is protectable copyright material as an art design or just a useful article that should not be protected. Is it our protected art or is it an unprotected commercial product? This is the Supreme Court's 2017 decision of Star Athletica versus Varsity Brands. Here are the basic facts. Varsity designs and manufactures clothing and accessories for use in various athletic activities, including cheerleading. Design concepts for the clothing incorporate elements such as colors, shapes, lines, chevrons, and do not consider the functionality of the final clothing. Varsity received copyright registration for the two-dimensional artwork of the designs, which were very similar to ones that Star Athletica was advertising. Star argued that Varsity did not have valid copyrights because the designs were for useful articles, which cannot be copyrighted. and the designs cannot be separated from the uniforms themselves, which also makes the designs impossible to copyright. On the other hand, Varsity argued that the designs were separable and non-functional, and therefore that the copyrights were valid and had been infringed. And here is the basic legal standard under the Copyright Act. The statute provides that a pictorial, graphic, or sculptural feature incorporated into the design of a useful article is eligible for copyright protection if it 1. Can be identified separately from, and 2. Is capable of existing independently of the utilitarian aspects of the article. That comes from Title 17, Section 101. So let's see what the Supreme Court said in terms of art versus commerce and how this came out. Here is the rule of law the court adopted to explain that definition of Section 101. Quote, "We hold that a feature incorporated into the design of a useful article is eligible for copyright protection only if the feature can be perceived as a 2- or 3-dimensional work of art, separate from the useful article, and would qualify as a protectable pictorial, graphic, or sculptural work, either on its own or fixed in some other tangible medium of expression, if it were imagined separately from the useful article into which it is incorporated." End quote. Further, the court said, "In sum, a feature of the design of a useful article is eligible for copyright if, when identified and imagined apart from the useful article, it would qualify as a pictorial, graphic, or sculptural work, either on its own or when fixed in some other tangible medium." From that, the court ruled that because the arrangement of colors, shapes, stripes, and chevrons on the surface of the cheerleading uniforms were, if separated from the uniform and applied in another medium, for example on a painter's canvas, they would exist as a 2-dimensional piece of art. Thus, the decorations are therefore separable from the uniforms and eligible for copyright protection. So those of you who voted protected art, well, you were right. This design could be separated from the useful article and exist as a design. And so the colors, shapes, design was protected. Let's now move on to more works of visual art. Now we will turn to United States copyright law as it relates to moral rights, where we will first do an overview of the moral rights regime under United States copyright law, and then look again at some specific creations and assess whether they are mere products or advertising type creations, versus whether they are artistic creations subject to moral rights protections of the authors. Let's start our overview here with some basic copyright principles. Copyright protects certain exclusive rights for authors: the right to control copies being made, derivative rights to make new works, public performance, and display rights. All exclusive rights belong to the author. This is a utilitarian and economic-based right given to those who create copyrighted works, and infringers can be enjoined or pay damages. Damages take a few forms. There are actual damages or statutory damages. Actual damages include the plaintiff's actual losses as well as the infringer's profits. And statutory damages can, if it is willful infringement, up to $150,000 per work infringed. In this sense, statutory damages allow for punishment beyond actual profits or losses, and allow jury to punish and consider others' factors. Here is a Supreme Court quote on the basic theory of it. "Even for uninjurious and unprofitable invasions of copyright, the court may, if it deems it just, impose a liability within statutory limits to sanction and vindicate the statutory policy of discouraging infringement." That is the Woolworth case you see cited there from the Supreme Court in 1952. Let's double-click on moral rights then as part of this copyright regime that allows us to explore the commerce versus art line. First, what are moral rights? Moral rights give the ability of authors to control the fate of their works even once works are sold. It comes from French droit moral, excuse my poor French there, but which phrase is understood to represent rights inherent in the artist's personality. This transcends contract or property interests and exists independently of the artist's economic interest in the work. The theory of moral rights is that the result in a climate of artistic worth is an honor that encourages the creator in the act of creation to ultimately create more art for society, This comes from the Berne Convention for the Protection of Literary and Artistic Works of 1886. The key idea from the Berne Convention is what we have highlighted in the middle for you. Independently of the author's economic rights, and even after the transfer of the said rights, the author shall have the right to claim authorship of the work and to object to any distortion, mutilation, or other modification of, or other derogatory action in relation to, the said work, which would be prejudicial to his honor or reputation. Berne member states had to meet a minimum level of protection for these moral rights. This was the centuries-long issue that held the U.S. from joining the Berne Convention. It runs against commercial transaction concepts of private property transfers and owners of property having free reign over their property. But the U.S. did eventually join and modify U.S. copyright law to account for this idea in 1990. This brings us to the Visual Artists' Rights Act of 1990. It was passed to comply with Berne. It is a limited creation of moral rights to specific artists. We will look at what kind of artists, what are the exact rights they are given, and what kind of works must they create to get such protection. On remedies, we will see it is the same as copyright, including powerful statutory damages remedy. There are two basic rights, one to integrity and another to attribution. So what exactly does it protect? Let's now double-click. First, the right of attribution. Here is the law. Rights of attribution and integrity. Subject to Section 107 and independent of the exclusive rights provided in Section 106, the author of a work of visual art shall have the right to claim authorship of that work, and to prevent the use of his or her name as the author of any work of visual art which he or she did not create, and further shall have the right to prevent the use of his or her name as the author of the work of visual art in the event of a distortion, mutilation, or other modification of the work which would be prejudicial to his or her honor or reputation. This comes from 17 U.S.C. Section 106AA. The second is the right of integrity. It says, to prevent any intentional distortion, mutilation, or other modification of that work which would be prejudicial to his or her honor or reputation, and any intentional distortion, mutilation, or modification of that work is a violation of that right, and to prevent any destruction of a work of recognized stature, and any intentional or grossly negligent destruction of that work is a violation of that right. Those are the two rights. So let's see how these rights collide with commerce versus art, and we will start at Burning Man. I've never been, and I think this is the closest I will ever get to Burning Man, which may be true for many of you, so don't worry, it's all PG. Is this art of an artist subject to moral rights protection if destroyed? Or is it a bus in the desert at the Burning Man Party Festival? Again, take a look. Give it some thought and vote in your mind as to what it is. And let's now see how you came out. Plaintiffs built La Contessa. This was its name, and it was a replica of a 16th century Spanish galleon, made for use at the Burning Man Festival. They acquired a used school bus and then put a fade over it with a whole decking and handcrafted figureheads, which was then taken to the Nevada desert, where the Burning Man Festival occurs every year. The bus was later stored at the defendant's property, and after time the defendant burned the wooden structure so the scrap metal dealer could take the underlying school bus. When plaintiffs learned, they sued, claiming that the La Contessa was a work of visual art under our moral rights law known as VARA. The defendants said it was a commercial object. Take a look again and change your vote if you want. Here is what happened. The case is Sheffens versus Stewart, reported at 825 F. 3rd 588 from the Ninth Circuit in 2016. The Ninth Circuit framed the question as whether the Spanish galleon was a work of visual art or whether it was applied art. The court ruled that an object is applied art as opposed to a work of visual art, where the object initially serves the utilitarian function, and it continues to serve such a function after the artist makes his or her embellishments to it. The focus is on objects that, in fact, continue to serve real utilitarian functions, as opposed to those which may retain the ability to serve utilitarian functions in theory. Applying that rule of law as to applied art, the court held that it continued to serve the utilitarian function of transportation after artistic embellishment, because it was used as a bus to move people around the desert event. Here's the rub of it. An object constitutes a piece of applied art, as opposed to a work of visual art, where the object initially served a utilitarian function, and the object continues to serve such a function after the artist made embellishments or alterations to it. A bus was utilitarian. Art is applied to it, and it is still used as a bus. Thus, it is not protected against the moral rights restrictions. A bus is a bus is a bus. The result? It was not protectable art within the moral rights parts of U.S. copyright law and was a functional bus. Now there was a concurrence that feared the test was too centered on whether the object retains a utilitarian purpose. The concurrence agreed this Burning Man bus was applied art, but argued that the test failed to properly look at the work as a whole in favor of this utilitarian test. Now look at this. It is a display of those painted tote bags, and you can see the display hanging at an event at the Leh Chinese American Museum of Art. The question again, is it art or a commercial merchandising item? Look at it and frame your vote. Here is what the case was about. Plaintiff was an internationally known artist and muralist list known as Sharktuov, who created shark-based images. The Los Angeles Chinese American Museum had a multi-month exhibit and asked him and many other Asian American artists to participate. He had showcased art at the museum before, and for this event, created 88 original pieces of artwork to be hung in the courtyard of the Chinese American Museum. He named his exhibit Year of the Shark Red Packet, and it was a series of 88 red tote bags that were silk screen, painted with a shark image, hand-embellished, and hung specifically in the courtyard of the museum. He chose to have 88 given the symbolic significance of 8 to his Chinese ancestry and community. At the end of the event, the hanging art was thrown away by city trash crews. Plaintiff sued under the Visual Artists' Right Act for the destruction of his artwork. The city said it was utilitarian objects, that is, it was a bunch of bags, and so was a commercial product and not art. So with that deeper background, here it is again. Change your vote if you want before we move on to see what the court held. So here is the case citation, and in full disclosure, I represented the plaintiff in the lawsuit. The case was Liu versus City of Los Angeles in the Central District of California, and the rulings on the dates are there for you. The district court held that there was one work of visual art comprising the entire group of 88 hanging tote bags. The one work was not utilitarian applied art when hanging and then destroyed. But the totes individually alone were applied art and utilitarian under Scheffens because after the bags came down at the end of the exhibit, they were to be sold as tote bags and so were utilitarian. So a lone bag was not protected, but the entire installation's destruction was protected. Here is the query it leaves you with. What about painting on a door? Or if famed artist Monet, as he apparently did, doodles or draws on a napkin, the medium matters and may impact the analysis of whether the art is protected or not. Now let's turn to another wrinkle as we continue our odyssey between the commerce versus art line. Take a look at this picture of a poster, and the question is whether the underlying poster itself is a work of art, or is it simply lawyer advertising? As you can see on there, it's a picture of a large group of different people from society. The citizenry. One has a little note saying lawyer above his head, and the question asked is, preserve the right to counsel now more than ever, with another statement that executive budgets threaten the right to counsel. Since we are all lawyers, this may be the closest we come to our understanding of art, if many of you like me do not feel very artistic. So as we are doing throughout this whole program, take a look at it and cast your vote. And then we will get going to see if you came out on the right side of the commerce versus art line. This lawyer art or advertising case takes us to the Second Circuit. The case is Pallara v. Seymour, 344 F. 3rd, 265 from the Second Circuit in 2003. Here is the story. Plaintiff Pallara was an artist who often was commissioned to make banners for private or corporate events. She was commissioned to make a banner for a one-day event in Albany for the annual Legislative Lobbying Day. The banner was erected in the Empire State Plaza on 10-foot poles. But no permit had been secured, so it was removed by city officials and destroyed in the process. Pallara was upset the banner was destroyed and so sued under the Visual Artist Rights Act, claiming the banner was political advocacy material and her one-of-a-kind work of visual art. The defendant claimed it was advertising material and promotional material, and outside the protection of the law. Here is what the court held. Although very artistic and creative, the banner was created for the purpose of drawing attention to an information desk as part of a lobbying effort, and the banner overtly promotes in word and picture a lobbying message. While the commissioning party's name did not appear on the banner's planned installation adjacent to the information table and its explicit lobbying message leave no doubt as to the banner's purpose as promotional and advertising material for the lobbying effort. Thus, because it was created for advertising and promotion, it is not a work of visual art. Those of you who chose commerce, well, you chose wisely. This work, while artistic, was not within the narrow world of moral rights categories for works, and so its destruction was not subject to suit. Now let us move from copyright to trademark to explore the art commerce line a bit more. Before we get into a case involving art versus commerce in the trademark world, the case involving the famous Hermes bag, let us start with some trademark basics. What is a trademark? A common synonym for a trademark is a brand name. Think as basic examples of Coke, 7-Up, Chevy, Google, or perhaps Star Wars. Trademarks can be words, sounds, numbers, shapes, smells even. They must connote a given company's goods or services as a source identifier. When applicable to goods, we call it a trademark. When applicable to services, we call it a service mark, such as Saks for selling clothes, Citibank for banking, or as in the case of my law firm, One LLP for legal services. Trademarks have been extended even to product packaging and certain non-functional product configuration features. Let's take a look at the range of trademarks in terms of strength and protection. 1. Generic. This is the common name for product used by many, and it has no protection. For example, National Bank for bank, or light for low calorie. 2. Descriptive. A mark is descriptive if it conveys an immediate idea of the qualities, characteristics, ingredients of the goods. It may have protection if secondary meaning exists. Secondary meaning exists where a descriptive mark has become associated with a single commercial source in minds of consumers due to extensive systematic use. Think as follows: Baby Brie for cheese, Honey Baked for ham, Vision Center for optics clinics. 3 is suggestive. A suggestive term echoes some aspect of the product or service, but the connection is not immediate and requires some imagination or perception to connect it to the product. It has immediate rights. Think Contact for adhesive paper, Playboy for men's magazine, Q-tips for cotton swabs. And 4th, arbitrary or fanciful marks. These are marks used in an arbitrary, unfamiliar way. Think as follows: Camel for cigarettes, Ivory for soap, Google for internet searching. So here is a good example to explore trademark limits involving the Star Wars trademark. And this is where George Lucas took on President Reagan. The case is from the 1980s and is Lucasfilm versus High Frontier, reported at 622 F. Sup. 931 from the D.C. District Court in 1985. Here are the facts. President Reagan's SDI program was designed to defend from a nuclear attack with weapons in space was known as Star Wars. If you remember, it was the idea of loads of satellites to create an iron dome of sorts over America to shoot down incoming nuclear missiles. So Lucasfilm sued lobbying groups on both sides of the SDI controversy, alleging that they were infringing the Star Wars mark by their use of the term in political advertisements and seeking an injunction. Here is what the court held. Plaintiff has no property right in the word Star Wars beyond its use as a denoter of goods or services as a trademark. Thus, use by others in speech not in competition is not a trademark use. Quote, obviously cannot regulate the type of descriptive non-trade use involved here without becoming the monitor of the spoken or written English language. End quote. In other words, there is no way that use by lobbying groups as referring to Reagan's SDI in political speech was creating confusion as to Lucasfilm's association with SDI. Here is the lasting quote from the case. Plaintiff is in the difficult position of objecting because what he has depicted as fantasy may be frightening when depicted as a potential reality. Plaintiff must be left to his own devices to maintain the strength of his trademark by making the differentiation clear and convincing. So now take a look at your next opportunity to vote, and this is a digital piece of art created by an artist of a variety of handbags that look like the famous Hermes Birkin handbag that is sold by the expensive bag company. The artist sold this as a digital non-fungible token, or what is known as an NFT, and called it a Meta Birkin. Is that a legitimate creation of art, or is that an improper use of someone's trademark? Ponder it and let's get going. The case is Hermes International versus Rothschild, reported at 678F. Sup. 3rd 475 put of the Southern District of New York in 2023. Hermes sued for trademark infringement. Claimed consumers would think that it was sponsoring the art given the use of the famous Hermes bag. The artist defended and argued that the works were works of art under the First Amendment. That is, he argued that the company could not stop one creating a piece of art using their brand. The court allowed that defense unless the defendant sought to intentionally mislead consumers into believing the digital art products were backed by Hermes. After a 9-day jury trial, the jury verdict was that Rothschild, a self-described marketing strategist, purposely sought with some success to confuse consumers into believing that his non-fungible tokens labeled Meta Birkins and his associated website, metabirkins.com, were affiliated with Hermes' iconic Birkin trademarks. The trial judge also said the artist was a straightforward swindler posing as an artist. So that is where what is claimed to be art is in fact commerce and outside the bounds of the law. The contrary case, of course, is Andy Warhol's famous pop art of Campbell's soup cans. He sold it as art and not as if it was an official product offering of the soup company. And so the art commerce line is there, as you can see in the context this time of trademark law, as the mediating force between art and commerce. This case was appealed to the Second Circuit. It heard oral arguments in November 2024, and as of mid-2025, we are awaiting a decision. The core question in the appeal is whether the use of another's trademark in an expressive work constitutes trademark infringement. The artist's basic argument on appeal is this. The Meta Birkin should have been considered an expressive work, and the use of the Birkin trademarks had artistic relevance to the underlying NFT works because the artist was commenting on consumer society and wealth. At the same time, a large part of the oral argument focused on the artist's intent as it relates to the use of the trademark. Stay tuned and watch the legal press to see if this creation returns to the art side of the line or stays out of bounds on the commerce side. Let's now look at another art versus commerce case in the context of trademark law. And this brings us to Jack Daniels. And if all this art commerce stuff is driving you to drink, by all means make an old-fashioned right about now. Take a look at this picture of the Jack Daniels bottle and the dog toy on the right. Someone made to look like the bottle with the words Bad Spaniel instead of Jack Daniels. And now before you cast your final vote of the day, we will see what happened when this issue went to the Supreme Court. Let's start by listening to part of the Supreme Court oral argument to see how the issues between art and commerce were being framed. We will specifically listen to the Jack Daniels opening pitch and then the Bad Spaniel's opening pitch, and that may affect your vote. Vote for the whiskey bottle or the dog toy. Is the dog toy art or is it too commercial? All you need to know as we wade into this oral argument is that the reference to the Rogers test is to a Second Circuit First Amendment balancing test in the trademark arena that seeks to mediate the role of trademarks as expressive art when used by others versus commercial misuse. So let's get going.
This morning in case 22-148, Jack Daniel's Properties versus VIP Products. Ms. Blatt.
Mr. Chief Justice, and may it please the court. This case involves a dog toy that copies Jack Daniel's trademark and trade dress and associates its whiskey with dog poop. After a 4-day trial, the district court found both infringement and dilution. The Ninth Circuit erroneously reversed both holdings. As to infringement, the Ninth Circuit did not disturb the trial court's finding of likelihood of confusion. It instead reversed by applying an exception to the Lanham Act that the Second Circuit in Rogers versus Grimaldi invented for movie titles. Under Rogers, an expressive work is allowed to confuse as long as the use of a mark is artistically relevant and not explicitly misleading. But the Lanham Act has no exceptions for expressive works. It bars using marks for any goods when likely to cause confusion as to origin, sponsorship, or approval. Artistic relevance has nothing to do with confusion, and both implicit and explicit uses can confuse. Nor does constitutional avoidance justify Rogers. Rogers doesn't plausibly construe any text, and there are no First Amendment issues to avoid. Trademarks are ancient property rights that necessarily restrict speech to protect investment and goodwill and prevent consumer confusion. And parodies can be confusing. Now, as a practical matter, parodies won't confuse when differences in marks, markets, or message, typically ridicule, signal that the brand company didn't make the joke. But absent these features, pervasive copying and trading off a brand's goodwill tends to confuse. And survey results showing consumer confusion indicate that the parodist did too much copying and not enough distinguishing. As to dilution, the Ninth Circuit held that the exclusions for non-commercial use mean non-commercial speech. That holding renders neighboring exclusions superfluous, and it nullifies Congress's decision to limit the parody exclusion to uses other than as a designation of source. This court should give non-commercial use its ordinary meaning, a use not involving the buying and selling of goods. I welcome your questions.
Mr. Chief Justice, and may it please the court. In our popular culture, iconic brands are another kind of celebrity. People are constitutionally entitled to talk about celebrities and, yes, even make fun of them. Jack Daniels advertised in its self-serious way that Jack is everyone's friend, and Bad Spaniels is a parody playfully comparing Jack to man's other best friend. And it's clear in this case that what Jack Daniels is complaining about is not Bad Spaniels as a designation of source. They're complaining about the speech, the parody, the comparison to dog poo and a Bad Spaniel, not the mark. Parodies on non-competitive goods like Bad Spaniels aren't likely to cause confusion as to source or approval. As this court recognized quite properly in Campbell, companies simply do not license lampoons of their own products. The circuits developed the Rogers test to protect expressive works generally, and it keeps the threat of extended litigation from silence and speech. That's particularly true when well-heeled celebrities go after parodists. The Solicitor General agrees that the general multi-factor test is usually applied does not work for parodies, and that the district court misapplied the factors here. More broadly, a test that convicts pure parodic speech, like Mutant of Omaha, nuclear Holocaust insurance, or Michelob Oily in a humor magazine, is broken. A test that requires significant resources to vindicate obvious parodies like Wal-Qaeda or Holocaust or Chewy Vuitton is simply the wrong tool for the job. If the court is inclined toward the Solicitor General's position, the court should provide more guidance to lower courts than simply, hey, keep that as a parody in mind, because the burden of litigating the irrelevant or inverted factors itself chills speech. Stripping out those factors, a more focused version of the general test would ask 3 questions. 1, can the court reasonably perceive the product's parodic character? That's taken from Campbell. 2, what is the proximity and competitiveness of the party's goods? That's taken from the standard test. And 3rd, does the parody otherwise fail to differentiate itself from the parodied mark? This test protects speech while denying a free pass to knockoffs and counterfeits. But fundamentally, the First Amendment is not a game show where the result is survey says I'm confused, stop talking. I welcome your questions.
So now you heard each advocate make their opening pitch on the question. If any of you had a change of mind in whiskey versus dog toy, think about it now, and let's see what happened when the Supreme Court decided it. So now we are finally at the case of Jack Daniel's versus VIP products. Here are the facts in a bit more detail than you may have picked up from the oral argument. VIP Products makes a squeaky, chewable dog toy designed to look like a bottle of Jack Daniel's whiskey. You can see it there on the slide. On the toy, for example, the words Jack Daniel's become Bad Spaniels, and Old No. 7 brand Tennessee Sour Mash whiskey turns into the Old No. 2 on your Tennessee carpet. As the court noted, these jokes did not impress petitioner Jack Daniel's Properties, which owns trademarks in the distinctive Jack Daniel's bottle, and in many of the words and graphics on its label. Jack Daniel's owns trademarks in the distinctive Jack Daniel's bottle and in many of the words and graphics on the label, and it believed Bad Spaniels had both infringed and diluted those trademarks. In the case, VIP conceded that it used the Bad Spaniels trademark and trade dress as source identifiers. It argued it was a First Amendment parody type use that can be protected. In other words, it argued that where a trademark is used not to designate a work source, but solely to perform some other expressive function, it can be a protected use. The Ninth Circuit sided with the dog toy. It held that the Bad Spaniels marks fell within a First Amendment exemption because the toy communicated a message, a kind of parody, about Jack Daniels. As the Supreme Court noted, VIP has said and done more in the same direction with respect to Bad Spaniels and other similar products. Thus, the Supreme Court noted that only question remaining is whether the Bad Spaniels trademarks are likely to cause confusion. That is, when a mark is used as a source identifier, the First Amendment does not automatically insulate the use. So Jack Daniels won, and the dog toys were on the commerce side of the line, not on the art side of the line. You can see the quote here. When instead, the use is at least in part for source identification, when the defendant may be trading on the goodwill of the trademark owner to market its own goods, any First Amendment balancing doctrine from case law has no proper role. Nor does that result change because the use of a mark has other expressive content, because it conveys some message on top of source. Here is where we most dramatically part ways with the Ninth Circuit, which thought that because Bad Spaniels communicates a humorous message, it is automatically entitled to First Amendment balancing-based protection. So sadly, as the case may be, you cannot buy those parodic-type toys for your dogs unless and until Jack Daniel's itself decides to start selling them. On our slide here is a quick high-level recap of what we went through today. Let's talk about it in a bit more detail now. From the substantive law perspective, we reviewed copyright law, trademark law, and the moral rights laws within copyright law that protect artist attribution and integrity. More specifically, we did an overview of copyright law to understand what it protects, as well as the remedies it provides for infringement. And specifically, as it related to the cases we looked at the specific issues of useful articles and functional articles versus copyrighted artistic creations. In the moral rights aspects to copyright law, we looked at similar questions as to what is the work of visual art in distinction to what is a utilitarian object or a piece of promotional advertising that cannot be recast as a piece of art or a work of visual art. We also did an overview of trademark law, both substantive trademark law in terms of what it protects, as well as the range of marks that can get protection. And a fun look at an early case involving Star Wars to see some of the trademark principles at work period. From there, we were able to explore cases coming out of the trademark context, which also addressed this line between art versus commerce in the trademark context and distinction, to our substantive discussion of the art and commerce line in the copyright context. We looked at a couple of the very early cases that come out of both copyright law and from the Customs Treasury Department case involving determinations by courts as to what is art or not art. In the context of the circus poster, we saw this very significant battle between Justice Holmes and Justice Harlan, and that battle and the majority and dissenting opinion in that case from the very early days of the 20th century casts a long shadow well into the 21st century today. Those fault lines have defined this art versus commerce battle for the last century and a quarter, and they will continue to into the future. Indeed, in a curious counterfactual, if the case had gone the other way, one can only imagine how different our world would be today if courts had been making the adjudications along the lines that the dissent there argued for. We probably would be in a world with far less robust intellectual property protections, with a far broader range of copying being given to others. Where you may stand on that monopoly versus fair use or free use type line may be defined by whether you agree with Justice Harlan on the one hand or Justice Holmes in the majority on the other hand. In any event, that die was cast in the circus poster case, which brought us to the metal sculpture case that the customs inspector decided to tax. And as you saw that metal sculpture, which I think to most of us today in the 21st century we would take for granted as being art, was challenged at the time, but was adjudicated to be art and not some sort of imported piece of metal or utilitarian object. We took a look at some of the costume cases involving the two-dimensional to three-dimensional transformation for purely functional reasons. And when it was only functional additions, we saw that copyright did not create a derivative work right. And then we saw the recent Supreme Court case involving the cheerleader uniform, which allowed us to understand that the design of a cheerleader uniform can be conceptually separated from the actual useful article that it inheres within. And therefore, that design is copyright protected, even though it's on a useful article for the sport of cheerleading. And of course, we all got to go to Burning Man well, kind of anyway. At least we saw what the Burning Man bus looks like, which kept this decidedly tame. And we saw that that was an example of regardless of how much cool artistic design had been placed on the bus, because it still principally served a utilitarian purpose, driving people around the act of destroying it, could not be framed as an act of destroying a work of visual art within our moral rights regime. We also looked at the case that, as I indicated to you, I litigated involving the art tote bags that hung in the Chinese American Museum in Los Angeles. And there we saw that the installation as a whole that was destroyed was a work of visual art, even if each individual bag standing alone would not be deemed a work of visual art. And perhaps as a blow to our community of lawyers, what looked like a very artistic and cool poster, to my mind at least, for that lobbying law day, was denied artistic protection as a work of visual art because it was simply promotional and advertising material. I guess that goes to show that we as lawyers have a hard time being seen as artists. And from there, we looked at a couple of cases ending and rounding out our day-to-day coming from the trademark realm, but cases which also define these fault lines between art versus commercial product. We saw the very expensive famous Hermes bag manufacturer who did not take kindly to someone creating and selling digital alleged artwork using the name of the bag and reproducing digitally at least copies of the bag. We saw how that piece of art or token that was being sold could be seen as a piece of art, but that it was source identifying to the manufacturer and was really too involved in the trademark use of it as a knockoff trading on the goodwill of the purse manufacturer. And stay tuned for the Second Circuit to rule ultimately on whether the artistic expression pushed it on the art side or whether the intent to associate with the famous bag brand made it an impermissible commercial product. This, of course, stands in contrast to the ideas expressed in our artwork that may make art out of pop cultural items like the Campbell soup can, but where that is being sold and shown as a piece of art only, and not somehow source affiliated with the manufacturer. We listened in on a snippet of the oral argument from each side in the dog toy case to see who we agreed with and how the issues framed the outcome. And if any of you have dogs like me, you will be most bummed by the decision from Jack Daniels, because you will not be able to get cool parodic dog toys made of Jack Daniels bottles. Or if you're like me, you may be partial to tequila, and I won't be able to get Patron Tequila dog toys. That's the way the case goes, and those were the lines on the cases that defined art and commerce. I hope you had fun learning in this program. I hope you took a look at the pictures and made your gut judgment as to how the case would come down on each one. And I hope you did well on the law, but if you did not, it is all right. That is what our Curious Lawyer Intellectual Property series is about, because now you know the answers to these questions, and you've had an interesting, curious walk down the line between art and commercial product that intersects copyright, trademark, and moral law rights. So let's end where we began. The core line that runs through our IP laws is that courts cut a wide berth to artists and do as little second-guessing of art as possible. The Holmes versus Harlan battle from the last century has been the defining feature of this question we still assess today. And at a higher level, you see the Harlan dissent animate courts today as they grapple with questions like the Burning Man bus. The fault liens were defined, but they are not dead, and they bubble up in different contexts. As always, if you have any questions, please email me. I love discussing with all of you the issues that we discussed in these cases, and I'm always happy to hear from you. Thank you.